Hi guys, I'm Ayushi, your mentor for law entrance exams, and welcome to Law Digest. So we are back with a series for family law. Now we are at the second part of the series, that is the second video that we are going to look today, where we are going to discuss some questions on the Muslim law. And I'm glad that you did like the first video before this, and we'll be continuing with our series. Just in case पहली video किसी की miss हो गई है, in case anyone has missed the earlier video, the link of the same has been attached in the top right corner. You can go and watch the same. And in future, if you don't want to miss such videos, you can subscribe to this channel and press the bell icon for instant notifications. So starting with the first question says, which of the following is essential for nikah? Now this is question 11. Why question 11? Because 1 to 10 we've already discussed in the first video. So nikah means marriage as per the Muslim law. I hope all of you must be aware of this. Now what is which of the following condition is essential for a nikah to happen, for a marriage to happen in Muslim law? There should be 2 witnesses. This is an essential condition. Then the words must be clear and not ambiguous. Further, the proposal and acceptance should be given in the same meeting. The offer to marry and the acceptance of the marriage should be in the same meeting. You must have seen in the movies as well that there is a sitting and people are sitting there. There are 2 witnesses who are present, and there is a priest who asks both the parties that whether you accept the marriage or not. Then the other person says Kabul hai. So that is proposal and acceptance in the same marriage. So all of the conditions are essential for a nikah to happen. Therefore, option D is the correct answer. Moving on to the next question. Which of the following marriage is considered to be a void marriage? Now, as per the Muslim law, what kind of marriages are considered as void? Hindu marriages में we've already seen that जो prohibited degree के under marriages होती हैं, या फिर सपिंडर relationship के under marriages होती हैं, या if the partner is totally insane, in those cases the marriages are considered to be as void marriages. In Muslim law, marriage will be considered to be as void marriage when the marriage happens with a woman who is wife of another. So here first option says major and sound mind. This is a point that should be there for a valid marriage. Then person suffering from partial incapacity. The Muslim law says that the person should be suffering from absolute incapacity so that a marriage may be considered as void marriage. Since it says partial, so this condition won't apply. And for the proposal by one party and acceptance by the other party, we've already seen this is one of the main conditions for a nikah to happen. तो ये reason नहीं हो सकता कि इसके वजह से marriage void हो. The correct answer here is option C. Moving on to the next question. Which of the following relations falls under the absolute prohibition in Muslim law? So, जैसे हमने Hindu law में देखा था कि there are some prohibited degree of relationships. Now, in Muslim law, how have these relationships been categorized? They are called as absolute prohibitions. Now, they are either through consanguinity. Consanguinity means same blood runs through the person. So, for example, there is a son and his mother's sister is there and he wants to marry her. This cannot happen because there is a relationship by blood between these people. The sister of the mother cannot marry the son of the mother. Then further, affinity. By affinity, these relationships are by blood. By affinity is by marriage, by love. So the relationships that come into place through marriage, then those are absolute prohibitions. For example, a son cannot marry his mother. So such relationships are prohibited. And further, fosterage means the person who is taking milk from a mother, he cannot marry that mother. This is through fosterage. So ये सारे ही relationships जो हैं ये fall करते हैं under absolute prohibition under Muslim law. Therefore, the answer to this question is option D, that is all of the above. Moving on to the next question. Which of the following does not fall under relative prohibition? So we saw absolute prohibition. Now what is relative prohibition? There are certain cases in which marriages are prohibited because there is some relative condition that's there. So now marriage with fifth wife, this is a relative prohibition because Muslim law allows marriage with maximum of 4 females. So a man can marry a maximum of 4 females and not 5. So the marriage that will happen with the 5th wife, that is prohibited. Then marriage without witness, is does fall under relative prohibition, because we saw one of the essential conditions of nikah is that it should be made in the presence of two witnesses. दो witness होने ज़रूरी हैं, और अगर witness नहीं है तो वो relative prohibition में fall करेगा. Then marriage with non-Muslim is also a relative prohibition, and therefore the question says which of the following does not fall under relative prohibition. All these options, they do fall under relative prohibitions, therefore option D is the correct answer, that is none of the above. Then moving on to the next one, what is meant by iddat period? Now in Muslim law, when you study Muslim law, a lot of times this word iddat appears. तो ये iddat period होता क्या है? First is period during which a wife is to live a pure and simple life and she cannot marry again. Yes, this is iddat period. Let's look at this second option, period which women have to undergo after divorce or death of the husband. This is also iddat period. So iddat period is something, the period which a woman needs to undergo after either she gets divorced or her husband dies. उसके बाद वो period wife को observe करना पड़ता है, which is normally of 3 months. Now during this period the wife needs to live a pure and simple life and she cannot marry again. So these two conditions are essential. This collectively mean that the female is observing an iddat period. Therefore answer is both A and B. Option C is the time when a female reaches her marriageable age. This is not iddat period. A and B form the iddat period. Normally it's 3 months, iddat period is 3 months. Further they are divided into further subcategories. Obviously if you are studying from any material, it must be given there, and if you are a part of our course, it's mentioned there that in which cases what amount of iddat period does apply. Then what is muta marriage? Muta marriage के लिए options जो हैं वो हैं, it is a permanent marriage that is capable of being dissolved only by divorce. Then second is temporary marriage. Third is marriage by a Muslim man with a Kitabiya woman. Kitabiya means Christian or Jew. And option D is both A and C. Now muta marriage is a temporary marriage, therefore option B is the correct answer. Moving on to the next one, what is meant by dower? Dower is called meher. Now dower is what? It is the money which the wife gets from her house to give to the husband. That is dowry and not dower. Muslim law speaks of dower and Hindu law speaks of dowry. It is the money or the property which a husband must give to the wife with acknowledgement for dignity as a wife. Yes, this money is the money that the husband gives to the wife at the time of marriage to acknowledge her entry in his life, and this is called dower. Option B is the correct answer. Option C says it is the money or property which a husband must give to the wife when the child is born as expression of gratitude. No such money or payment is made in Muslim law when a child is born. Therefore, option B is the correct answer here. Now, the next question. Which of the following are not the sources of Muslim law? Quran, just like for Christianity, Bible is the book, the main source of law. In Muslim law, Quran is the main source of Muslim law. Then Ijma and Qiyas. So all these three, they form part of the sources of Muslim law, and none of the above is the correct option here. Now what is Ijma? Ijma, it means that a consensus has been reached between the Muslim jurists, that is called Ijma. So something that's not given in Quran, it can be arrived through a consensus between the jurists. And Qiyas is something that is arrived through analogical deductions by comparing something with the standard that already exists. Then the law that comes into place is called Qiyas. Moving on to the next question. Which of the following is a Sunni school of law? So we know that in Muslim law, the community is divided into mostly two broad categories, Sunni and Shia. Now, under the Sunni school of law, Hanafi, Maliki, Hanbali, all these three schools are present, and therefore option D is the correct answer here. Let's look at the schools of law in Shia school. In Shia school, Itna Ashariya, Ismailiya, Zaidi. All of the above, they form a part of the Shia school of law. So with this we come to the end of this video, and I hope that you got to know a few things about the Muslim law. Just in case you want to read up the Muslim law fully for the purpose of your exam, what you can do is you can go to our website www.lawdigest.in. There you will find a module on family law, and family law covers both your Hindu law as well as Muslim law. And just in case you have any further queries on this video, you can mention the same in the comment box below.